Dan Tehan, during the winter recess, you travelled overseas to the US, Britain and other places looking at anti-terror measures. One of the things you looked at was the British system of closed courts. Just tell us, how do they work?
Well, what we were particularly interested in was the use of what they call special advocates. So these are security-cleared barristers who can represent those who have been accused, especially of terrorist activities, and where the government, through the police force or agencies, want to bring in classified information into the courts, which they do not want disclosed. These special advocates represent the interests of those that have been accused, but they're security cleared, so it means that the information won't be leaked or won't get out into the public, and that protects the sources of the intelligence agencies, which is obviously absolutely crucial.
So this isn't a measure to prevent terrorism, it's a measure to prosecute those accused of terrorist-related activities.
One of the issues they had to deal with in the UK is that they obviously there's a long history, sadly, of terrorist activity dating back to Northern Ireland. And so what they've had to do, the more court cases you get, the danger is that the more likelihood through what you're bringing forward to prosecute, there is chances that your sources, given patterns of behaviour, etc., could be jeopardised. So given the amount of cases they had and the types of cases they had, they looked at what are the best ways we can make sure that we can try and prosecute to the best extent possible those who we believe are guilty of terrorist acts, but at the same time, how do we keep the information, which we think proves that, secure, because if we don't, it runs a great risk of threatening our ability to be able to keep that nation, to keep the UK safe.
It's a difficult balance though, isn't it? Because there's that old saying that justice should not only be done, it should be seen to be done. These will be closed courts with the defendants themselves very often not able to see the evidence being presented against them.
That's right. So the special advocate gets to see the evidence, and they're able to give a briefing to the accused, but in giving that briefing to the accused, they obviously have to do so in such a form that in no way jeopardises the intelligence sources which have been presented by the prosecution. So you're right. In a perfect world, it would be better if we didn't, if they said if in the UK it wasn't necessary to have to put in place these types of measures. But the sad reality is in Britain, they've had to deal with terrorism, they've had to deal with terrorism cases, and they wanted to make sure that where they thought people were guilty of acts and they had the information, that material could be brought to court. And what they were finding was that they weren't able to bring certain material to court, which was meaning that people were walking free.
A couple of practical issues. What happens if one of these defence barristers applies for a security clearance and they get knocked back? That's a pretty controversial thing for a government to be ruling out perhaps a very eminent barrister from appearing in these cases.
Yeah. So look, I don't think that was an issue. There's a pool of these special advocates, so there's about 30 of them. We actually met with a former special advocate who'd done it for 10 years and then had decided to step down from the role. There's only a certain type of barrister who wants to apply to be a special advocate, and they go through a normal sort of security clearance process that you or I would do if we wanted to either join our intelligence agencies or wanted to take on one of these roles. And so you do always run the risk that there might be something in your past that means that you're disqualified. But they were able to get a very good pool of special advocates together.
So do you think this example, what Britain is doing, that it has merit to be considered to be introduced in Australia?
Look, we were interested to have a look at it. Obviously, it's specific to the British court system. It's specific to the British democratic system and the principles that their judicial system operates under and their legislative system operates under. Whether it be directly relevant here in Australia, look, I'm not an expert in this area, so I couldn't say. But the thing that was interesting from our perspective was that they're dealing with this issue of how do you try and protect material which you think proves someone guilty, especially of terrorism activities. How can you go about and do that? Now, they've come up with a particular system to do it. It is likely, given the increased activity we've had here in Australia, that we might run into risks along these lines. So we were just very interested to have a look at what they've done in the UK.
Let me ask you that, without reference to the British model, do you think here in Australia that there is a weakness, if you like, in our system of being able to use classified information in prosecuting those accused of terrorism-related crimes?
Well, I think I would leave that up to the police and the agencies as to whether they see that as a problem or not. But one thing that is clear, I think, is the more, sadly, that you do have prosecutions, the more you run this risk. So that's the problem that we face, sadly, here in Australia, because we are seeing, sadly, more cases of terrorism-related activities. So it might be a concern into the future. So, look, we obviously were over there looking at a range of different things, revocation of citizenship. We looked at special advocates in the UK. Obviously, there were some broader national security issues that we were also getting briefings on: Iraq, Syria, what's happening with Daesh. So there was a range of issues that we discussed, but this was one we were interested in.
You've been talking a lot in the public and in the media in the last couple of weeks since returning from your trip on some of these national security issues. You were talking about the possibility of the RAAF having bombing missions in Syria. I'm wondering,
just on that, Chris. Also, there was.
Talking about.
But there was two sides to my argument there, and one got a lot of attention, as you could imagine. Yeah. The other one, was to me was equally as important and deserves an equal amount of attention, and that was the humanitarian crisis in Syria. And we've got over 9 million people who are internally displaced.
You certainly made that point in the first two answers you gave in our interview.
So I think we can't forget that element as well as the point I was making. But anyway, go on.
My question wasn't about that. It was whether you've run this past the Prime Minister's office, whether you're authorised to talk about it, because we've had the Prime Minister just yesterday telling the party room he's told ministers and whatever that they shouldn't be freelancing, they should stick to the script. You're not a minister, but as the chair of the Joint Intelligence and Security Committee, you bring some weight to these issues. What's the answer?
So, just on Syria, the Prime Minister had said a couple of months before my intervention that we hadn't ruled out the possibility of maybe needing to go into Syria. So he'd been asked that question specifically and said we hadn't ruled it out. Obviously, I went over there and I listened. I heard. We had very an extensive list of meetings both in the UK, France, and the US. And I had what I thought was a very considered position that, as a backbencher, I'm entitled to do. Obviously the Foreign Minister has said some things on this. The Prime Minister had said some things previously. I thought my intervention was very much in line with where the public comments that the Foreign Minister and the Prime Minister had said. Obviously, they had said hadn't ruled this out. And my view was, as a backbencher, I was perfectly entitled to make a case that we need to do something. And I firmly believe that. And I would say one of the things that I've been that gave me some not pleasure out of this, but some substance to what I'd said was the fact that it was able to stimulate a debate, that we had editorials in The Age, we had editorials in the Herald Sun, we had a lot of opinion people out talking about this issue. So I thought very much that as a backbencher I'd done my role.
What do you think then of these reports, this sort of analysis in some of the media that you've been used as a kind of a stalking horse for the PMO?
Well, you're damned if you do and you're damned if you don't, aren't you? It's this was something, and I'd be happy if you could talk to the relevant ABC journalist and relevant Herald Sun journalist that I talked to before I wrote my opinion piece, because we'd been discussing this well and truly before the week of the debate on same-sex marriage, and they'll happily validate that. So if I had been to the Prime Minister and said I'm doing an opinion piece on Syria and this is exactly what I'm going to say, then I would have been a stalking horse. When I say, well, look, no, these were my own views, but I thought that they were consistent or not inconsistent with the government's position, then you're out by yourself, against the message, etc. It's very hard in this game to be seen to be doing exactly the right thing. But my view is that this was a personal belief. I felt strongly about it after what I'd heard in Europe and the US for 2 weeks, and I wanted to put it out there. And it's not the first time that I've done this. If I believe that something needs to be said, I'll do it. As you know, early in the year, I said it about the GST, and if I in future, if I think there are things that I strongly believe in and need to be said, I believe it's my role to do it.
Okay, Dan Tehan, thanks for your time.
Thanks, Chris.